Earlier this year, Democrat lawmakers introduced a new piece of legislation into Congress that will make it illegal for Americans to form militias. The bill, which you can see up on your screen, was introduced to both the House as well as the Senate, and it's officially titled the Preventing Private Paramilitary Activity Act of 2024. Its stated purpose would be to explicitly outlaw the formation of citizen militia groups here in America. And more specifically, according to the text of the bill itself, it will create federal criminal penalties for people who engage in certain activities, including the following: publicly patrolling, drilling, or engaging in harmful or deadly paramilitary techniques, intimidating elected officials, interfering with government proceedings, pretending to be law enforcement, and so on. Now, perhaps ironically, this bill likely had the opposite of the intended effect, at least on the public. Because I know for myself and several people who I spoke to, after hearing about this bill, our first reaction was, can we form private militias? I mean, if they're trying to outlaw the formation of militias, that must mean that it is currently legal to do it, right? Well, after looking into it, the answer is a bit complex, to say the least. And so, let's go through the legal framework surrounding militias as it currently stands, what this bill is trying to actually outlaw, as well as the central question of whether you, as an American citizen, can go ahead today and form your own militia. Now, to start with, let's begin at the very foundational document in play, the Second Amendment. For a long time, one of the main arguments circulating online against private gun ownership was that the Second Amendment does not actually give people the right to own guns. The argument typically goes something like this. The Second Amendment doesn't actually allow people to own guns. It only allows the state to own guns in order to form something like a National Guard. Now, the reason for why this view exists is not a mystery. It's because in the modern context, the plain language of the Second Amendment is a little bit confusing. Just for your reference, here's exactly what the Second Amendment to the U.S. Constitution says. Quote, "A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." And so it's quite easy to look at the surface of those words and assume that the right to keep and bear arms really does only apply to militias who are in service of defending a state. And in the modern context, that is something like a National Guard. However, that is not in fact true. And to understand why it's not true, we need to do two things. Firstly, we need to smash those like and subscribe buttons so that this video can reach ever more people via the YouTube algorithm. And then secondly, we need to look at a case that was put forth in front of the U.S. Supreme Court back in March of 2008, a case that's called District of Columbia versus Heller. In that particular case, what happened was that the city government of Washington, D.C., they instituted a host of different anti-gun regulations, including making it illegal for a person in D.C. to own a gun unless that person received a license from the chief of police. And the licenses, they could only be issued for 1 year at a time, meaning in a practical sense that you needed to go and renew your license every single year. And so, amidst these new regulations, a man who was living in Washington, D.C. named Richard Heller, he went to the chief of police to get a gun license. He was denied, and therefore he filed a lawsuit against the city government, arguing that in the way that they were conducting themselves, they were violating his Second Amendment rights. The case eventually found its way all the way up to the U.S. Supreme Court, where the principal question to be determined was whether or not the Second Amendment to the U.S. Constitution protected the right of the people to keep and bear arms. And after hearing the case, listening to the oral arguments, and deliberating for about 3 months, well, the majority decision by the U.S. Supreme Court was that it does. The Second Amendment to the U.S. Constitution does protect the people's right to keep and bear arms. Here's a short summary of the conclusion from that majority opinion. Quote, "The term militia should not be confined to those serving in the military because at the time, the term referred to all able-bodied men who are capable of being called to such service. To read the amendment as limiting the right to bear arms only to those in a governed military force would be to create exactly the type of state-sponsored force against which the amendment was." Now, to understand their rationale here, let's dissect the Second Amendment, starting by defining two specific words that it contains. Firstly, what did the founders, writing in the year 1791, mean by the term militia? Because today, we usually conflate militia with something like a state-run National Guard. But that's not what the word meant back then. In the late 1700s, a militia referred to all free men who were capable of bearing arms. Basically, a militia was defined as all able-bodied free men. Here's in fact how the majority opinion of the Supreme Court described it. Quote, "Unlike armies and navies, which Congress is given the power to create, the militia is assumed by Article 1 of the Constitution to already be in existence. Congress is given the power to provide for calling forth the militia, and the power not to create, but to organize it, and not to organize a militia, which is what one would expect if the militia were to be a federal creation, but to organize the militia, connoting a body already in existence. This is fully consistent with the ordinary definition of the militia as all able-bodied men. From that pool, Congress has plenary power to organize the units that will make up an effective fighting force." Meaning, in plain English, that the term militia was understood at the time to mean all able-bodied free men. And so that's the first term, militia. The second term that we need to define within the context of the Second Amendment is reference to defending the security of a free state. And so what exactly was meant by a free state in the year 1791? Well, unlike today, in the modern day, where the word state typically refers to an individual state like Oklahoma or Kansas, well, the use of the term a free state in the late 1700s referred to nation states, what we today would refer to as countries. Here's again the U.S. Supreme Court on this particular term. Quote, "The phrase security of a free state meant security of a free polity, not security of each of the several states. It is true that the term state elsewhere in the Constitution refers to individual states, but the phrase security of a free state and close variations seem to have been terms of art in 18th century political discourse, meaning a free country or free polity. Moreover, the other instances of state in the Constitution are typically accompanied by modifiers, making clear that the reference is to the several states. Each state, several states, any state, that state, particular states, one state, no state, and the presence of the term foreign state in Article 1 and Article 3 shows that the word state did not have a single meaning in the Constitution. And so, taking these late 1700 and early 1800 definitions into account, here's how the Second Amendment to the U.S. Constitution would read if it was written today but still conveyed the same meaning. A well-regulated body of free men, being necessary to the security of a free country, the right of the people to keep and bear arms shall not be infringed." Then the U.S. Supreme Court, they spent a good amount of time in this ruling going through the relationship between the prefatory clause and the operative clause of the Second Amendment. And without going into too much detail and too much legalese, what they were basically laying out is that the first part of the Second Amendment, the prefatory clause, explains the reason for why it is necessary, while the second part, known as the operative clause, explains what the right actually is. And so essentially, in order for free people to defend the free nation, the right of the people to keep and bear arms shall not be infringed. All right, just to pause here for a super quick moment, I'd like to introduce today's sponsor, which is a great company called Patriot Mobile. And they really are a phenomenal company because while it's safe to say that there is a concerted assault on America's values happening right now, companies like Patriot Mobile are bucking the trend and they're standing firm. I mean, as a company, in both their actions as well as their spending, they strongly support the First and Second Amendments. They strongly support the sanctity of life, as well as Americans' veterans and first responders. And better still, besides just having really good values, they are actually a good company. They have great phone plans. By switching to Patriot Mobile, you'll still get the same awesome nationwide coverage as the big providers, because Patriot Mobile actually operates across all three of the major networks. It's just that by switching, you'll be doing business with a company that doesn't undermine your values. Plus, they back their service with a coverage guarantee. 100% of their customer service is based right here in the US, meaning they're keeping the jobs here. You can keep your existing phone number, and you can either keep your existing phone, or if you'd like, you can upgrade. And so just head on over to patriotmobile.com/Roman, or just call 972-PATRIOT. Right now, they're having a special promotion where you can get a free month when you use offer code ROMAN. That's ROMAN. And so consider making the switch to America's only Christian conservative wireless provider. Either call the number, or you can just click on the link right below this video. And furthermore, when you look at it through a historical lens and bear in mind the historical context, well, the true intention of the Second Amendment becomes rather clear, because the founding fathers of this nation, they did not write the Second Amendment in order to go hunting, like people nowadays imply. They had just finished fighting a bloody war against their own monarch because that monarch had become tyrannical towards them. And after that war concluded, they codified the Second Amendment to the U.S. Constitution, not so that Americans can go hunting, not even so much that we can protect ourselves from petty criminals, but rather the Second Amendment in the Bill of Rights was put there to protect the citizens of the Republic from their own government if and when that government becomes tyrannical. It was written to give the people of the states the ability to protect themselves, their families, and their communities from a government that might, at some point in time, become a terror to its own people. Now, with that as the actual general backdrop, the next logical question becomes, how do people execute this responsibility? Because if you own a gun, and I own a gun, and Dave owns a gun, and Mike owns a gun, well, that's great, we're all armed, but we are not well regulated. Well, here's where things get a bit, you could say, messy. Back during the time of the founding of this nation, well, there were many militias. In fact, Alexander Hamilton, while he was a student over at Columbia University, he would quite literally spend his mornings drilling with a volunteer student militia before then going off to class. However, after the founding of the country, laws were enacted one after the other which limited paramilitary activity to be only allowed if the group conducting that activity is subject to the state. For instance, in the late 1800s, there was a law passed over in Illinois which forbade, quote, bodies of men to associate together as military organizations or to drill or parade with arms in cities and towns unless authorized by law. That particular Illinois statute wound up getting challenged. The challenge wound up making all the way up to the U.S. Supreme Court, and in 1886, the U.S. Supreme Court ruled that these types of laws, which make citizen military organizations illegal, do not violate the Second Amendment. Then, about 20 years afterwards, something known as the Militia Act of 1903 was passed into law. This piece of legislation, it created the modern framework for the National Guard, which sits now underneath the U.S. Army, and then later also underneath the U.S. Air Force, and it also codified a new definition of militia into the U.S. Code, creating two distinct subclasses. According to Title 10 of the U.S. Code, Chapter 12, subsection 246, the organized militia includes the National Guard and the Naval Militia, while the unorganized militia includes all able-bodied men between the ages of 17 and 45 who are either American citizens or have declared an intention to become an American citizen. And so here's exactly where we get to the heart of the matter. The organized militia is the National Guard, while the unorganized militia consists of all able-bodied young men. However, those able-bodied young men are not allowed to do their own thing. That's because at the state level, right now, all 50 states have some form of restrictions, either in their state constitutions or as just statutes in the books that limit private paramilitary activity. Up on your screen right now is a report that came out of Georgetown University titled Prohibiting Private Armies at Public Rallies. And this report, it identifies 4 different types of anti-militia laws that exist throughout the U.S., as well as which particular states have those laws enacted. The first type is a constitutional provision that requires military activity to be governed by civil authorities. 48 states have that provision written into their state constitution. The second is a statute that prohibits private militia activity without the authorization of a state government, which 29 states have on the books. The third is a type of statute that's on the books in 25 states, which criminalizes certain paramilitary activity, such as conducting public drills, as well as demonstrating the use of either firearms or techniques that are capable of causing death. And the fourth type of law is a prohibition on falsely assuming the uniforms or functions of law enforcement. 17 different states have these false assumption statutes on the books. And so, as you can see, all 50 states have at least 2 of these prohibitions. Some states have all 4. And these different laws have the combined effect of making it pretty much illegal for paramilitary groups to do almost anything in public. Although, this is exactly where you begin to brush up against the First Amendment. Because if you think about it, if I'm allowed to own a gun, and my friend Dave is also allowed to own a gun, and Mike is also allowed to own a gun, and we're all allowed to train with our respective firearms, and then, as per the First Amendment, we're all allowed to associate with each other freely, at what exact point does our association and exercise of our rights cross the line into illegal paramilitary activity? For instance, what if we go into the woods to practice shooting? Or what if we form something like a volunteer search and rescue group and we all carry guns for defense against bears and coyotes? Or perhaps even more pertinent, what if me and my buddies all happen to live in an open carry state and we all want to go to a protest and we all happen to bring our rifles? Does all that fall under the purview of these laws? Because each one of those things is a legal activity. At what specific point does it cross the line and become illegal paramilitary activity? Well, to answer some of those questions, Congress recently held a meeting. Specifically, after several events, after the alleged kidnapping plot against Governor Gretchen Whitmer, after the shooting deaths over in Kenosha, Wisconsin with Kyle Rittenhouse, as well as after what took place on January 6th, all these events, you can say, reignited the efforts of those on the political left to crack down on militia groups that they claim are instigating violence and suppressing people's rights. And along that line, the House Subcommittee on Civil Rights and Civil Liberties, they held a meeting to, quote, examine the role of militia groups in the current rise of right-wing extremism. This congressional meeting was held in May of 2021. It was led by Democratic Congressman Jamie Raskin, and it was conducted under the banner of several different meetings that are confronting violent white supremacy, something that the DHS claims is the biggest domestic threat currently facing U.S. security. And during this meeting, you had Ms. Mary McCord, who is both a former federal prosecutor as well as the woman who was behind this report right here, which detailed the anti-militia laws throughout the U.S. And here's what she said regarding the legal framework that's currently in place in the U.S. in respect to militias. And for your reference, I'm going to speed up the clip just a little bit so that we can get through it faster.
Unfortunately, there is a widespread misunderstanding that private militias are constitutionally protected. But private militias are not authorized by federal or state law, they are not protected by the Second Amendment, and they are unlawful in all 50 states. First, since before the founding, well-regulated has always meant regulated by the government. Historically, the militia consisted of all able-bodied men who could be called forth by the governor when needed and were answerable to the governor. The well-regulation of the militia was baked into the U.S. Constitution, which gives Congress the power to organize, arm, and discipline the militia, a power it exercised by authorizing the state militias answerable to state governments. And it was baked into the constitutions of nearly every state, which required that the military always be strictly subordinate to and governed by the civil authority. Second, the Supreme Court has been clear since 1886 that the Second Amendment does not protect private militias and that states must be able to ban them as necessary to the public peace, safety, and good order. The Supreme Court reiterated this in 2008 in District of Columbia versus Heller, which held for the first time that the Second Amendment protects an individual right to bear arms for self-defense. Justice Antonin Scalia, writing for the majority, pointedly contrasted that individual right with paramilitary activity, restating that the Second Amendment does not prevent the prohibition of private paramilitary organizations. And third, all 50 states prohibit private militias, whether through their state constitutions or other state laws.
However, despite that fact, there are well over 100 militia groups currently active throughout the U.S. doing everything from patrolling the streets during protests, to marching in the streets themselves, to trying to keep businesses safe during riots, to even going down to the U.S. southern border and helping Border Patrol to stop illegal migrants from being able to pass through. There's even a large all-black militia group currently active that has a stated purpose of creating their own state within a state.
Appearing by the hundreds at protests from Stone Mountain, Georgia to Louisville, Kentucky, demanding justice for police killings and countering what they believe is the threat of right-wing militias. It's a movement started in 2017 by this man, former musician and Army veteran John Grandmaster J. Johnson.
What makes us so different is that our goal is our own government, our own country, a place where we can determine our own future.
Is violence an option to reach your goals?
The United States was built on violence being an option. Violence should be the last option.
And notice something. These militias are operating out in the open. They are giving interviews to the media, and very often at events, they are marching right alongside the police. And this is happening because despite the myriad of laws on the books throughout all 50 states, well, these laws are very rarely enforced. And there's a number of reasons for why that is. And here's, again, Miss Mary McCord speaking to Congress, describing some of them.
These state laws are rarely enforced. They're not well known to local law enforcement. Some local officials lack access to information to build cases or mistakenly believe that private militia activity is constitutionally protected. And some local officials lack the political will to enforce anti-militia laws, especially in areas with a high number of pro-militia voters. Congress should consider a federal anti-militia law. A federal law prohibiting private militia activity in public while armed could provide a civil enforcement mechanism in addition to criminal penalties, allowing the U.S. Department of Justice to seek injunctive relief and civil forfeiture against armed paramilitary actors and their organizations.
And that's exactly what happened. Shortly after that congressional meeting, the Preventing Private Paramilitary Activity Act of 2024 was introduced to both the House as well as the Senate. It now has 10 co-sponsors, all Democrats, and if passed, it would empower the federal government to prosecute those people who are engaged in militia activities. Because right now, the federal government cannot do it. It is a state issue. But with this law, if it were to pass, the DOJ can step in and prosecute the people who either start or join militia groups. Now, as to whether this bill can actually pass into law, it's doubtful. Right now, it's dead in the water. It will not make it past a Republican-controlled House or even a split Senate. However, in the future, you never know. With these types of things, you have one event that sparks public outrage, and all of a sudden, politicians fall into line and they can pass legislation through like that. Regardless, though, that is where we currently stand. All 50 states have laws in the books that ban organized paramilitary activity in some way. It differs from state to state, but by and large, forming what we commonly understand as a militia group is technically illegal. However, the laws against it are rarely, if ever, enforced. And if they were to be enforced, there might very likely be an appeals process that would reach all the way up to the U.S. Supreme Court, because on the face of it, many of these laws do seem to be in conflict with the First Amendment. Now, looking through the reams of legal case files, the most recent case that's even remotely relevant to our discussion was from 2017, where Miss Mary McCord, the woman who was in that video speaking to Congress, she sued several of the militia groups that showed up in Charlottesville. She used the anti-militia laws in Virginia as the basis of her lawsuit. However, that case of hers wound up getting settled, and so it's unclear how it would have actually played out in court and through the appeals process. Regardless, that is the situation as it currently stands. If you'd like to dig through my research for yourself, I'll throw those notes down into the description box below this video if you're the type of person that likes to dig into the weeds. And then also, I would love to know your thoughts, because there really are two different ways to look at it, like anything else. On the one hand, it appears that if you go by the intention of the founding fathers, well, I don't know if you can say that their intention would have been to empower state governments solely to form militias, because it would seem that there's no reason to assume that the federal government and your local state government could both turn tyrannical. And then what? You don't have a militia to defend yourself? So it doesn't seem plausible that the only meant that the state government would have a monopoly on militias. However, on the flip side, it would be hard to have a normally functioning society if anybody who wishes to at any given time can form their own roaming militia and patrol the streets with open carry guns if they so wish. So I guess there would be a balancing act. And as of right now, and for the last 250 years, the courts have interpreted it to mean that militia power should belong to the states. But I'd love to know your thoughts. Do you think that's correct? Or do you think that goes directly against what the founding fathers intended? Please leave your thoughts in the comment section below. I'll be reading through them later today as well as throughout the rest of the week. And then until next time, I'm your host, Roman from the Epic Times. Stay informed, and most importantly, stay free.
Hey everybody, how's it going? Welcome back to Copper Jacket TV. So we've got something very important to talk about. The big news of the day is that the military has been authorized to use lethal force against U.S. citizens, and this comes from a DoD directive, specifically Directive 5240.01. We're going to go over that directive. We're going to talk about exactly what it says, what it is supposed to be for, and we're going to talk about whether or not the military would actually do that, if this is something that you think they would do, because I've heard from some people that they just don't think they'll cross that line. So let's talk about what's going on here. Now, before we get started, I want to tell you a little bit about today's sponsor, which is Delete Me. Delete Me is an amazing service that will allow you to get your online privacy back. Believe it or not, there are data brokerage sites out there whose sole focus it is to gather, sell, and distribute your personal data. So what is Delete Me and how does it help? Well, Delete Me is a company that cares about your personal privacy, and so what they do is they collect your information and they scour the internet and search those data brokerage sites to remove your personal information. Now, I personally have a Delete Me account. As a matter of fact, I've been using their services since December of 2023. And in that time, they have scanned 111,056 listings and removed my information from 44 different brokers. Now, one of my favorite things to do with my Delete Me account is actually check out the online dashboard. From there, you will find all of the relevant information that you need, from the number of listings that were scanned, how many times your information popped up on a data brokerage site, what type of information popped up, from your age, your address, your name. It will break everything down for you so that you can see how Delete Me is working effectively for you. So if your online privacy is important to you like it is to me, make sure you join Delete Me. You can use the link down below to save 20% or use the discount code COPPERJACKET. Okay, so let's go ahead and talk about what's going on here. And before we talk about whether or not the military would actually go along with something like this, let's take a look at the DoD directive itself, talk a little bit about it. It's kind of a long directive. It names lists of priorities, implementation, the people who are responsible for implementation, people who would be connected to it, and there's a lot going on here. It's not just a 1 or 2 page document. There's something like 20 plus pages. So this is a very long document to go through. If you guys are interested, I'll put a link to it down below. But it's definitely worth reading and keeping up on stuff like this because, again, this is stuff that comes directly from the top. So here it is right here. This is DoD Directive 5240.01. It is the DoD Intelligence and Intelligence-Related Activities and Defense Intelligence Component Assistance to law enforcement agencies and other civil authorities, and the originating component is the Office of the Undersecretary of Defense for Intelligence and Security. You can see the date there, September 27th, 2024. So you can see right here, it says, this issuance implements paragraph 2.6 of Executive Order 12333 as amended, except as otherwise specified in this issuance. This issuance applies to all defense intelligence components when providing intelligence assistance to law enforcement agencies or other civil authorities. This issuance does not apply to activities conducted by the National Geospatial Intelligence Agency pursuant to Section 42, Title 10 U.S.C., humanitarian assistance, disaster readiness, response, recovery, maritime and aeronautical safety of navigation, environmental and security vulnerability studies, mapping, charting, and geodetic missions. So this is the part that has everybody concerned because this is what can be provided by the DoD in terms of personnel and materials to assist local law enforcement or other agencies against U.S. citizens. It says, assistance in responding with assets with the potential for lethality or any situation in which it is reasonably foreseeable that providing the requested assistance may involve the use of force that is likely to result in lethal force, including death or serious bodily injury. It also includes all support to civilian law enforcement officials in situations where a confrontation between civilian law enforcement and civilian individuals or groups is reasonably anticipated. Such use of force must be in accordance with DoD 5210.56, potentially as further restricted based on the specifics of the requested support. Provision or use of DoD unmanned systems in the United States except as delegated by the Secretary of Defense pursuant to October 31st, 2023 Secretary of Defense Memorandum. So again, we're talking about military personnel, we're talking about equipment, and even unmanned equipment here. Now, they say they're going to do this within the constraints of the U.S. Constitution, but if you believe that, I should let you know that I give free unicorn rides out back. Now, it says that right here in policy, it's actually paragraph A, DoD intelligence and intelligence-related activities will be conducted in accordance with this issuance. Applicable laws, EOs, including EO 12333, as amended, presidential directives, DoD D5148.13, Secretary of Defense Memorandum, and other DoD policies and DoD Manual 5240.01, special emphasis will be given to the protection of the constitutional rights and privacy of U.S. persons. Now, what they're talking about there in terms of privacy is that in this memorandum, it says that they can assist with the collection of data on people that are involved in certain situations, and that they won't directly collect data of U.S. citizens unless it is somehow part of the collection that is required for whatever it is that they're trying to get. So basically, if you get caught up in it, if you get rolled up in this, then your data will be collected. It's very similar to like the Patriot Act, right? Where they might be collecting data on somebody else, but then your data inadvertently is part of that, and so they can collect that as well. So that's kind of what's happening here, is that they're going to be collecting data and surveillance, things like that, and they just want to say that they're not going to do it on people that are not directly involved, but those people who may be indirectly involved might still get caught up. This thing's a whole mess. Now, interestingly enough, I've had talks like this with people in the past where you talk about whether or not the military would actually use force against civilians, you know, regular Americans. And the answer that I get is really interesting. There's some people who just think that it won't happen. If that order was ever given, or they were ever faced with a situation where they would actually have to go face to face with American citizens, they think that the military would just simply back off. And I can assure you, from talking to people that I know in the military, that is not the case. That might be the case for some. There's some people whose moral compass will point them in the right direction. And then there's other people who don't have a moral compass. They have an agenda, and they would be perfectly fine with it. I'll tell you right now, they would just be gung-ho with it. As a matter of fact, I bet you there's some people that are just waiting for something like that to happen. But saying that it outright wouldn't happen is a fallacy. All we have to do is simply look back in history. If you ignore history, then you might be wondering what could happen with this. If you are somebody who embraces history and takes a look back, I guess you could consider even recent history. Just take a look back at recent history. You can see that that is not the case, and the military would 100% go along with something like this. Now, I wholeheartedly support our military, 100%. Those men and women who stood in line, who volunteered, knowing that one day they may have to make that ultimate sacrifice. You know, sacrifices like staying away from your family for long periods of times, missing birthdays and holidays, you know, and all the stuff that they have to go through in order to do a job that a lot of people just won't do. A lot of people who wouldn't volunteer to do, they're the ones that are out there doing it, and I support them for that. But you know what? You one day might be faced with a dilemma, a very serious dilemma, and you might want to hash that shit out now so you know exactly where you're at. So this is, to me, very concerning that they would put something out there like this. I mean, it may be in support of local law enforcement. It may be in support of some other agency. And so if it comes down to it, maybe, you know, just things might be stretched thin for whatever reason. But I think we all know why this is happening and why this is coming down. And this is definitely a moment for self-reflection to figure out exactly how we got to this point, because a memorandum like this, I don't think was necessary in the past. But now all of a sudden it's coming out. I just think it's something worth talking about, and I wanted to share that with you. So I want to thank you all very much for watching. I really do appreciate it. Please like, subscribe. You guys have a great day.